Good morning, morning. Welcome, I hope everyone can hear us. Welcome to our series our second in the series of patent focus webinars. So we're glad to have you join us here in the JIPO studios that we call it. And we're pleased to be here this morning to be able to discuss these issues. So I'm Marcus Goff, Deputy Director Legal Policy here at JIPO. With me is Mr. Jason Wanson, the Assistant Patent Manager. Sorry, sir.
Good morning, Dr. Goff.
Yes, you're right.
It's okay.
Yes, so we thought we would do a more discussant version, of the presentation and of the webinar this morning to be able to share and to engage with the online audience in that respect. Yes. So let's make sure everyone is hearing us. Please, you can indicate that everyone is hearing us. But again, welcome, good morning to all. Please to have yours. Yes, sir.
So this morning we'll be discussing the new patent procedures and and versus the old patent law. So we'll be looking at various aspects of the new law versus the old law. So we'll be trying to go through some of the very poignant parts of the new law. Right?
So just put the slides down.
Yeah.
And okay, so
So, so what the first thing we'll be looking at this morning is that how the new law will repeal the 1857 Act, and we'll be looking at the factors that make this law TRIPS compliant, right? But first, one of the things that we would really like to look at is, in recognition of February being Black History Month, we'd like to look at some of the important people and some of the important inventions by Black people or people of color. So we're looking at Mr. Garrett Morgan, who is the inventor of the traffic light. I think it's a very significant invention. People might see it as a nuisance, but it is a significant invention that we've been looking at in this time, right? And we'll look at another great inventor, Mr. Louis Latimer, right, who is the inventor of the carbon light bulb. Now, up to recently, this version of the light bulb was the main use of light bulbs, right? And then we'd like to look at Mr. Alexander Miles, who was the inventor of the sliding doors for the elevator, which is another key invention. So invention is a key part of our lives, right? And it is a key component to what we are doing in this. So we are constantly innovating, we are constantly creating, and one of the things that we have to understand is that this is important for our development.
very much so, Mr. Wanson, very much so. I mean, I think we oftentimes don't get the opportunity to look at more of ourselves as being creative and scientific persons, and just go to show you that, Black people are at the center of creativity and of innovation for
Hundreds of years.
centuries.
Yeah.
I was saying actually, Jason, that man, Mr. Latimer, you kind of resemble him, Jason. Yeah, he's one of your ancestors.
Well, he might be, because, he was a great inventor. I wish I was as equally as good an inventor, but he was a great inventor. And so, but we have to realize that throughout history, the innovations that we take, we might see as annoyances or nuisances right now, but they were great inventions, and we need to capitalize on these inventions, and we need to look at it. So that's why the law has to be up to date.
Definitely. So, looking at the as the one time said, the comparison in some respects, the old law and the new law, right? Of course, they've had a patent law in Jamaica for quite some time, 1857, and we recently passed the Patent and Designs Act 2020. And so, in that respect, the new law will bring the patent procedures into conformity with international standards, the element of the TRIPS agreement, and will also be a more modern and effective, simplified process for our creative person to be able to get their inventions protected. So, in terms of the definitions, if we look at the old law, we call it, it defines invention, discovery, and improvement as meaning any manner of new manufacture or new mode of manufacture, the subject of letters patent. And it speaks to the grant of privilege of the letters patent in that regard. Right? It speaks to the patent being a letters patent, which of course is also old language in old law, in terms of this exclusive rights granted to you by the sovereign on the letters patent. Whereas the new law defines patent, Section 4 of the 2020 Act, as the title granted for the protection of an invention, which meets the criteria prescribed in Section 4. Essentially, that it is new, the invention, it involves an inventive step. It is that the invention is new, involves an inventive step, and is capable of industrial application, and is not excluded from the grant by the legislation. Right? So the definition is also important, of course, is recognizing international standard in terms of that. And so it's important for us in terms of just laying out what will now be this new standard and definition for an invention. So in terms of the next slide?
Yeah, next slide.
Yeah.
So when we look at the definitions of a patent, what we're really looking at is the basic the basic means to the invention. So we're looking at really we're solving a problem, right? And this solution to that problem is really the solution to that problem is really where the invention and the innovation lies. And the new legislation really highlights that fact that we're looking not just at discoveries, but we're looking at the innovation in the law, right? So, okay. So
as you say, Jason, I think that this is just again comparing the new law, the definitions in terms of opening, comparison of the framework, and that is something that I think is also just important for us to bear in mind. How these definitions have changed over time.
Right. So so the applicant for a patent really is one of the key factors in all of this. Who can apply for a patent? And so under the old law, an applicant could actually by himself or through his attorney apply for a patent. But no, the new law specifies who can really apply. So anybody, right, can apply for a patent, right? Either sole, alone, or by joint, right? Person claiming to be the inventor. So anybody who is claiming to be the inventor can apply for a patent in this under this law, which is very important because when you look at it, we really are trying to identify who has rights and who has rights to an invention. So that is a very important fact that very important distinction in what the new law is saying, right? And I hope that we can look at that fact that the new law is really speaking to those new aspects, right?
Yeah, I mean, I think the wording in the old law is quite long and lengthy. This is something that again is a feature of the old law, but essentially giving the right to the applicant, who is the inventor or somebody who's representing him, as you say, right? Or who has improved. So the old law also talks about an improvement, right? And talks about the person being the inventor. Now the new law, section 9, speaks to the persons who may apply for the patent, also including someone who may be the successor in title, right, of any of the above persons. So maybe you would have obtained it through a parent or through a company, through some other kind of succession in that regard, or you may have been an assignee, you may have been assigned the patent as well. You can also apply for registration.
So the old law is a little,
was narrow.
It was narrow in terms of how it treated with who can apply. So it gave our applicants a difficult time in some cases, but how the new law sets it sets out who can definitely be an applicant. And it also is very important to know that these comply with how TRIPS are set out, the who can apply. So that's very important to note.
So the old law, of course, in the procedure involves several steps, which, of course, also are centered around the Governor General being the one who's issuing or granting the first patent. Right?
Yeah.
So, Jason, maybe you could take us through the current process here.
Sure. So really what happens is that right now you have to make your petition to the Governor General. So he is the one that is granting the letters patent because he's the Queen's representative in Jamaica, right? You have to make a declaration declaring that you are the true and first inventor of this patent, right? And by this declaration, you are saying that I am the true inventor. So in a lot of cases, in a lot of instances, the declaration that you write might not be true because you might not actually be the inventor, but you might be his emissary, right? So you have to be that's something where you have to take into account. The specification, though, is always filed in duplicate because it always takes into account. Well, this is from 1857 when photocopiers probably didn't exist or weren't invented yet, and so you had to file the application in duplicate so that the owner of the letters patent would get back the original, and the office would keep an exact replica of the letters patent so that we would have a record of that person filing the application. And then you would have to file any deeds and powers of attorney as necessary. So those are some key factors to what obtains under the current law.
Right, of course. Under the current law, the old law, the law talks about the absentee applicant,
right?
And so the need for some power of attorney, authorizing someone here to be able to represent him or her in that regard, and thus the declaration sometimes having that kind of a legal fiction, But yes, coming back to the days when, of course, it was all paper-based.
That's right.
And it was also more territorial-based, Jamaica.
Yeah.
Which we'll look at shortly too. So that, because we're going to talk about the Jamaica context and who is based here, applying here through someone based here.
Yeah. So
that's what
that is also true. And then one of the other things that we have to look at is what were the conditions for the grant? Because the conditions for the grant really were very, very different under the previous legislation. So the conditions for the grant really were looking at novelty and novelty meaning it must have been new in this island, right? And it must have public utility. So there are two. So the law was really looking at two very basic genres of how patents were. So it was just looking at, is the thing new and did it have use to the public? It wasn't looking at anything other than that, and that was a very key component. So we were looking at those things, and one of the things that I think is that this particular aspect of the law had to be addressed, because this kind of really allowed us to almost receive almost any kind of patent. So so the new law really does define what really in depth, and we'll go to the slide, what patentability is. It really more defines what patentability is, and it gives you that structure. Because people come to me all the time and say, but I've never seen this on the market before, and therefore you want a patent. It's not because you haven't seen it on the market before does it really qualify for invention, but the law does say that. So, that's how we got ourselves into accepting a lot of applications that maybe in a wider world would not have qualified for patent. So that was a key feature of why we needed to upgrade the law. So we looked at under the law, we have your petition, you have your declaration, and you have your specification in duplicate. But so really, it was just a matter of filing these own legal documents.
So have those changed
Well,
much? I mean, I guess we look at it as a soon,
we will look at it.
the essence seems
The essence
to
is still there, but it has changed, right? So when we look at the old procedure now, we look at somebody coming into JIPO, and when the applicant comes into JIPO, he submits his application. His application is forwarded to the Attorney General's office, and then the Attorney General makes recommendation as to who should examine the application, right? So he makes a recommendation to that person, and he sends it back to JIPO, right? He makes a recommendation to JIPO. We now send it off to the examiner. Right now, it's only two examiners we really have, the Bureau of Standards and the government chemist, where they make a recommendation to examine. If the application is approved, we write back to the applicant, and he has to publish for 4 consecutive weeks in either a daily periodical or the newspaper. Then he has to bring all his publications back to the office. When he brings his publications back to the office and his letters patent, we forward it to the Attorney General. We send it back to the Attorney General. So the Attorney General plays a role in all of this, because the Attorney General is who is under law entitled to do all of this. JIPO is just doing the administrative. Then, after it's granted, the petition goes to the Governor General, and the Governor General, he actually signs the letters patent. So it's a real involved process involving a lot of moving parts of of different organizations. So this adds to the length and the process of what happens right now. So this is probably one of the most key things that needed to be addressed with the new law, because it was all over the world, and this is actually written into law, because an agency like JIPO didn't exist in 1857. So when you look at current procedures, right, we're looking at the current procedure is, again, as I said before, we go through, we receive the application, the application goes through the processes. Since I've described it already, I'm not going to bother telling the audience how the procedures really go, because that is all of the procedures, right? But in 2020 now, this is one of the key things that we need to look at. Under section 10, you have a form 1, and all the form 1 does is you are basically making a request for the grant, right? And in addition to the request for the grant, you have your specifications attached, and your specification basically contains your description of the invention, right? Your claims, your drawings, and your abstract. So what your specification document contains, no, it's all contained in that form 1. And that is key. So we're trying to simplify the process for the inventor. And that simplification of the process should lead more people to want to file patents, rather than having to go through the whole process of going to the stamp office and coming back and all of these things. Everything is done at JIPO basically. So we've simplified the process.
Right. I think it's a good thing, certainly having a standard form, with instructions and with notes and that kind of thing is always useful, to help applicants, as you say. So I think this definitely should help the system to be more user friendly.
Yeah.
And hopefully get more persons to utilize it.
And that's what we're aiming for, is a more user-friendly system to try and simplify the not just simplify the process, but simplify usage. Because right now, when people hear the word patent, they cringe, right? And it shouldn't be. It's not. Patent is not more difficult than any other IP, really.
That's right.
But it's just that the phobia attached to it is more difficult than other IP. So when people hear the word patent, they just right away start to run away, or they just start to pull away the chairs and say, "Hey, I don't want to really deal with this." But it's not that difficult, and I think probably the old English and the law that we're existing under really added to that mystique. So those are the things that really added to the complexities. So when we look at the request for grant should contain the names of each applicant, meaning that each of the people should be there, right? It should be the name of the invention, right? The names of any agents, right? Those are the things that we need to, and the title including the subject of the invention. So a brief overview of the invention is always necessary, right? Filing date. This is a very key component of the invention. Under section 10, really, right? The filing date is a very key component. So the filing date really contains the date that we had filed the invention and that the invention was first, or where the invention was first filed, right? So the filing date can be any one of the dates, right? Then it comes to another key component.
Hold on, Jason. Go back there. What do you mean? You have to clarify. What do you mean by filing date?
So
any one of the dates. So
truth be told, and this is really what I was getting to under section 12, right? You have something called the priority, right of priority. So I could be domiciled in Jamaica and file 6 months ago, and I can claim priority in another territory, and I get the date that I originally filed. So your filing date really can be up to 6 months prior because of where you filed the application. So the priority date, which is under section 12, really is a key component now. So your filing date can actually be up to 6 months prior to your filing in another territory. So you would have up to 6 months to claim priority in another jurisdiction.
Right, but that doesn't mean that the filing date is changed.
No,
the priority is different from the filing date.
No, but yes, but your filing date actually is hinged on that priority date because you can claim that priority date. So based on wherever you file your application, you can claim that priority. So if you're in a WTO country, once you're in a WTO country, you can claim priority in any other jurisdiction, and it impacts your priority. Suppose if you didn't have that filing date, that previous filing date, you'd have to use today's date, right, as your filing date. But suppose you want to get to the market early, or you want to use that date to introduce the product. That filing date is really important.
Right. All right, but when we say priority, I think we should explain that we're talking about a period of time wherein which you as the applicant have the ability to file the application in other states and get the priority date, the date from which the application will be examined for novelty, being that of the filing date of the first application. Right? So it basically gives you a time frame wherein which you can be able to file your applications overseas, right? And have them be prioritized in terms of the first in, first out system that is maintained in the IP regime. So, as Jason said, very important, because of course, when it comes to examination, if someone else files something before yours, or with an earlier priority date than yours, it can mean yours will be refused. And so it's important that where priority dates are allowed and permitted, which of course they are required under the Paris Convention, that they will be applied and be available to the person who want to use it.
Yeah, so it is important to mention also that priority date we mentioned on your form number 1, which is your application form. So your application, it's important to mention on if you're filing for priority on your form 1, it's important to mention mention that date on your priority and give evidence of that priority, right? So one of the key other things about priority to mention is that you have up to 6 months to file that priority claim. So you have 6 months to file any priority right. If you don't file within the 6 months, you cannot claim priority. So if on the 7th month you come into the IP office and you want to file the patent, you cannot claim that previous date. You have to get today's date, right? So it's very important that time is a factor if you're claiming priority, right? So that is a key component of priority, right? And one of the other things that we need to know about priority is that the applicant, right, shall on his own initiative furnish the office with any information about that overseas grant, right? So that's a key component to also know. Now, mention of an inventor. Now, this is a key component right here, is that everybody who is an inventor has the right to be mentioned, right? He must, under section 14.1, he must be mentioned as an inventor. And so everybody who actively participates in the invention should be mentioned, unless, you know, the inventor really, by some declaration, does not want to be mentioned. And if that is the case, then he has to file a declaration saying that he doesn't want to be mentioned on this invention, right? Or else he will have to be mentioned.
So, what do you see as the significance of this new provision?
Well, the significance is to highlight, give accolades, similar to any other IP right. Give accolades to the person who add to the creativity. Now, if I specifically don't want those accolades, I have to say that I don't want those accolades, and it puts it in writing that I don't want those accolades. So it's important to know that you're going to be mentioned as an inventor, but because you have that right, and you have that.
Sure, let's say you get the recognition,
right,
the attribution, and
right.
Possibly a share of proceeds too.
Yeah, you know, any proceeds from that invention, you have to, you know, look at it from that. And one of the key also things is that in an invention state, when the invention is being examined under section 15, you have to look at it might, yeah, your invention might, what you have described is actually two inventions. And the registrar has a right to say that you've now had two inventions, not just one. And you have to divide the event because you're claiming for more than one invention. And this has happened in a lot of states where you're applying for one invention, but then your invention has to be divided because there's actually another invention contained within that invention. And the new law actually gives you the opportunity to divide that in. So you maintain that filing date, but you actually divide the invention, the application into two. So now you will maintain your original filing date and actually divide the application, which is an advantage because maybe you didn't see that you had two inventions, but now you see that you have two inventions. So that's a key component of the new law, is that it affords you that opportunity, right? And so really and truly, a lot of things new features are available under the new law. It does make the fact that you can under section 16, it does allow for preliminary examination, right, which allows the applicant to communicate in writing any details that you might have omitted as an applicant. So the office will communicate to you anything that you might have omitted or that is lacking in your application, and allow you the opportunity to make remedies for that, right? So the publication of an application. So no, has been a lot simpler under the new law. Your applications will be published in the Jamaican Intellectual Property Industrial Property Journal. So meaning that you don't have to go to the Gleaner and you don't have to go to the Gazette anymore. Your publications will be done within JIPO. So it saves time, it saves money, and it simplifies the process of you having to run around and get those publications done. JIPO will actually do the publications for you, and that's a very important thing to know. Again, it's all about in the process of simplifying the process, right? And that's important to know that the process is being simplified, right? So section 18.1 really talks about amendments. So after we asked you to really make any amendments to your application, we give you that opportunity to improve your application should it be lacking anything, right? 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 So search and substantive examination, we are going to still utilize the facilities of our local examiners, right? We're going to still offer substantive examination where possible. But JIPO is trying to widen the pool of examiners, and we're trying to widen the pool of who can examine a patent. Those are the things that we're really looking towards. So we're looking for patentability, and we're looking for a more universal approach to substantive examination. So we're still going to utilize our local examiners. So our local examiners out there, don't feel that the process is going to change significantly. We're just going to utilize a wider pool of examiners, and we're going to basically still utilize our examiners, and we're going to still use our examiners, and we're going to give them more tools what to be looking for in terms of patentability. You know, it's a novelty, inventive step, those things. So our examiners know exactly when they pick up a patent application what they're looking for, and we'll be training examiners as to help them and give them the tools to equip them to be ready to examine the patents, because we still have to examine the patents. So those are some key things that we really have to look at in terms of what we are going to be doing, right?
I think it's important, that we try and raise the skill set, of the local inventive community, inventor community. Young scientists who are doing work in different areas, in schools, the research that's being done in universities, in colleges, and the various scientific competitions that we have. We need to kind of have a way to channel that into some, productivity that can result in patents as well. And so the new law, I think, is certainly a good tool, as I said, to kind of fuel that.
Right. So that is a key component, and a key thing in the law is really about the examination. This is a key component, and I think this is an area that we really have to develop. So to our examiners out there, we are going to rely on you heavily also to develop the process. So if we can do that, then I'm thinking that we will definitely be improved in the process. As Section 20 looks at, the registrar shall take into account any search and substantive report. So we will be getting these reports, not just from you guys out there, but we will be getting our reports from anywhere we can, from JIPO, we might be getting our reports from substantive search bodies out there. So search examiners. So we are looking to really widen the pool, and this is something that we really have to take into account, that we are going to try and get our search entities out there very very much developed as this in IP offices or IP organizations around the world. They have hundreds of examiners. So we don't have the capacity to host hundreds of examiners inside JIPO. So we definitely have to go out. That's one of the things. So grant and refusal, this is a key thing. Section 22.1 speaks to once the applicant has, so no, we have a very kind of, under our current law, we don't have a real set grounds. Once a patent is new and novel and useful, it should be granted. But no, we have definite terms and conditions under which the patent would be granted. So first, so when you look at the definite clauses under Section 4, we're looking at the conditions of patentability, right? Section 5, looking at novelty. Section 6, looking at inventive step. Section 7, looking at industrial capability. Section 8, really looking at the exemptions to patent, right? And Section 9, looking at persons who are qualified for patentability. So when you're looking at when you satisfy all those requirements under those sections, you will get a grant for a patent, and that is very important to know, right? That you will get a patent once you satisfy. So it's not a matter of does the examiner like you or not. It's a matter of once you satisfy all these conditions, you will get a grant, right? Okay, so this is also another very key component of the new law, terms of the patent, right? So the terms of the patent really is 20 years from the filing date. Again, the filing date comes back into key. So the filing date says 20 years from the date of filing. So we're looking at 20 years, so a limited term of protection for 20 years, right? And that is a key component, looking into that element of the patent law. So we're looking at 20 years. 20 years is a long time. I mean, it might not be long in terms of a lot of things, but 20 years seems to be a long time, right? And one of the key components of that 20 years we know, which is highlighted under section 25, is the annual fee, right? And the annual fee must be paid on the anniversary of the application. So this is a very key component right here, right? So it must be paid on the prescribed fee from the prescribed on the form 8 from the fee schedule. That is on part B. So what you're looking at is a really key component of the fee schedule, and the fees must be paid annually. So each year the fee goes up based on however long you have, but it starts out at a very minimal cost, and that is something that we really have to look at.
If we leave the fees though, Jason,
Uh-huh.
I think this is also something to note that at present, under the current law, there is no annual fee that is charged. And this is again a feature of international patent practice. So that the new regime will, with its modernization, also will bring additional fees that will be payable. And so the fee will go up for the filing of the application, as well as there will be an annual fee payable up to the 19th anniversary of the filing. As Jason said, that will ascend gradually. Right? And again, this is really there not to tax persons so much as to incentivize the creators, the inventors, to use, to commercialize their patents. Right? Because of course, just registration alone doesn't bring the benefits to you of your creativity or of the IP system. So by having this annual fee that gradually increases each year is really there to again motivate inventors that they will have some incentive to go out there and to commercialize and earn. So very important as well to bear in mind. Of course, the very archaic fee structure that we have currently will also expire soon, and that will then have, of course, the new fees in place thereafter.
Yeah, and that's very key to bring us to the next slide, is that if you really want to utilize the existing fee structure, now is the time to file a patent. But it brings me to the next slide, utility models. So when you look at a utility model, if you look at the criteria for a utility model, it really looks at new and novel, and it looks at industrial application, which sounds very similar to our current legislation. So if really what happens is that the new patent law really does look at kind of adapting the old ways, but it's under the utility model, which is for 10 years, not 20 years, but it's for 10 years. So it's kind of adapting the old regime where it's not as stringent of patentability, but it is for a lesser period of patentability. So this is something. So really, what we're kind of doing is encompassing the old law under the utility model regime, and I think that is something that is kind of unique to this area, as that we're still kind of adapting or giving our applicants a channel to use the new law, but it does give them some sort of protection for the patent or the innovations that they come up with.
Yes, quite right. And this is also again useful for persons who are along the process of inventing. Maybe you're not at the stage where you have a full-fledged patent or something like that. You could qualify the patent, but maybe you are still at a stage where you want to protect it, you want to be able to commercialize it, perhaps, and you can have this as a alternative form of IP right. So it's really the introduction of a new IP right, as it were, for inventions, and one that is more affordable, more accessible. And so we hope that will also be a new positive introduction that will be utilized by the public.
Yes, definitely. So that brings us to a very key component right here, which is the Patent Corporation Treaty, right? What deals with, and we're going to have follow-ups to the PCT, so we won't go in depth about the PCT, right? But it is a key component that this treaty allows people to stay from Jamaica and file internationally, as well as the vice versa, where people will be able to file from international aspects in Jamaica. So one of the key components of the PCT is the PCT allows you to file, it gives you time, and it gives you a good idea as to what your patentability will be in the future versus right now. So you're looking at PCT allows, if you look at the traditional system where you have 12 months to file all throughout the territories that you're looking at, PCT extends that time, but it gives you 12 months to file your PCT application, then go through the processes of your PCT application before you have to file in what we call the national phase. And that's one of the key things that we'll be looking at, right? So PCT is a new component of the new law, and that is one of the features of the new law that we really need to be looking at.
Okay, all right. So thanks, Jason. Thanks for that. Very useful. So we want to open up the floor to any questions or comments. We have some time remaining, so we would love to get any feedback. That's like a question here. Can you explain the priority date versus the filing date? Is it that question?
Okay.
Yeah, I see a question here. Just going to bring up the question. You explain the priority date versus the filing. The priority date is right. So, all right. So when we talk about the priority date, right, it is related to looking at novelty, right? So when we speak of the priority date, we're talking about the date from which your invention be deemed to existed purpose of comparison with other applications, right? So IPCC is based on a first-in system whereby your application will be prioritized based on the file. To say that if someone else files one day or so or more after the application, yours is first in line. Is that you and that person have a similar application? The one that is filed earlier will get the preference, right, in terms of having or for the purpose of novelty to be treated as the one that is novel in that regard, and the one that is filed just after yours, therefore, on that basis, have lost its novelty in that respect, right? So it's really about how the examiner is going to examine the application at the point in time when the application is being examined. And so your application, for example, may be filed. Let's say that your application is filed on the 1st of July. That would be the filing date of your application, right? It's filed at the IP office. But if it is that application that you have filed here at JIPO, the 1st of July, is based on application that was filed um, elsewhere, right, within the priority period. So maybe you filed application in USA in January, right, of that same year, and then you filed in Jamaica on the basis of that USA application, right? Then when time comes for your application in Jamaica to be examined, right, have been filed here, it will be examined as the novelty from the date of the first filing in that first country, right? So that therefore you get that additional period of time where your application would still be treated as novel. It would not have to contend with application that would have been filed, right, in Jamaica after your January filing. You still get that priority date to be treated as if it was filed in Jamaica. So the date of the first filing. But for the purposes of the term of protection, right, the filing date would still be from the actual filing in the territory. I don't know if that is clear. There's some feedback.
All right.
Okay. All right. So I see one question
Dr. Goff.
here.
Dr. Goff.
Good morning. Is it mandatory going forward to file locally before filing a PCT application?
No, it's not. It's not. If you wish to file locally, it's just that it's easier to file locally because you can file through your local IP office and then send your application internationally. But it's not mandatory, but it would be easier. So we're encouraging you to file through JIPO as well, and then before you go to your PCT, because it will be easier for you to monitor and to control that application. But it's not mandatory. If you want to go to another territory, suppose we have other inventors in another territory, like the university would, for instance, have its counterpart in Trinidad, and they want to file from Trinidad. That would be it could be considered. It could be done there. So those are the things you have to consider.
I mean, we do want to encourage local filing, though, because what it also does contribute to is the statistics national for Jamaica on patents. Right? When patent applications are filed by Jamaicans from overseas, from outside of Jamaica, then that data sometimes doesn't get picked up, and again that lends to the fact that we say that Jamaica isn't doing anything or Jamaicans aren't inventing, but sometimes again the statistics don't get accurately logged, and that I think also feeds into this perception that we're not inclined towards invention. So we would certainly encourage persons to file locally. Certainly is even with the increased fees, much cheaper than filing a patent in most of the countries around the world. And certainly, as I said, we build the local capacity, both of yourself and of the local agents and of the IP office as well.
I have another question.
Another question from Ms. Hansen.
What is the difference between
When the new fees for examination come into effect? So the new law has not yet been brought into effect, right? Reason being that we are trying to coordinate the PCT accession of Jamaica with bringing the new law into effect. Because that's a substantial part of the new law, of course, the PCT. And so what we are aiming to do is to have the two time frames coincide later on this year. We don't have exact data yet. We're working through the accession process with JIPO and getting ourselves ready for that. But we expect that in another few months we will have that in place and the new law and the new fees will be applicable.
The old law and the new law has the publication.
Right. So I'm just working off of what are the questions I see on the chat. So, or if you want to write it, but I mean, just yeah. So that's it. So let me see. Has the new patent act been passed? hopefully. In terms of the other question from the audience, Mr. Husband, you were saying in terms of the difference between the old law and the new law in terms of what aspects? Let's see a question on that. So, any more questions? Please type them and let us know. We'd like to answer. Just long time, just waiting. Anything about the new law that you think is that we left out or that you want to emphasize?
Well, I don't see. There are many things that we left out, but there nothing that really is of any benefit at this time. So if anybody has any questions, really, I would encourage you to ask it because we can answer them now. And this is the time that we're encouraging you to really to put forward the questions because the questions are important at this point. Right?
Okay, what's the difference between the old act and the new regarding publication?
Well, that's a very important thing. Publication is much simplified under the new law. So rather than having to publish 4 times, and I think this again really looks towards the public whole under olden times, you had to publish multiple times to capture a greater audience. Right now we can publish less and still capture a wider audience. What the publication really is speaking to just advising the people out there as to what is being filed and how it's being filed. So our publication right now is actually reaching a wider audience, and so we will publish right now we will publish 2 times right now, and those 2 times will either to facilitate any opposition out there. The opposition period really is out there to really facilitate any opposition to any application.
What is to be published?
Well, basic information about the application, who filed it, the content of the specification is out there to be published. So basically, anybody can oppose the application at that point. So you're looking at information that will allow anybody out there to oppose any application.
Okay, I see a question. Where can we access the JIPO publications and patents? So, yeah.
So the JIPO publications and patents will be available online in the future. And this will be a key feature of JIPO online is that so both for wherever you get your trademark applications as your patent applications will be available online so that people can have the access to them once they want to know about any individual application. So once it's published and once the information is published, we will be able you as a public will be able to access the information publicly.
All right, so is there any more questions? I see one more here. Is the determination of novelty focused on the Jamaican context and reality as far as the invention?
Interesting question. So the novelty will be determined by when you publish the application, the novelty will be determined by universal novelty. So if somebody has published any information in Jamaica, that information will be determining whether we are seeking or the novelty will be locally or not. Yes, well, so it really is
No, well, I think the question is about the new law. So the new law is going to be in terms of worldwide novelty.
Yes, it will
So
be.
the Act speaks to that in terms of the process for a modern IP system, and that is what will be the new regime. Right?
Right. So the new regime will be focused on universal novelty.
Right. Is the annual fee a set figure? So yes, the annual fee is a set figure each year. It's in the new law. Just when we were to include a slide or a link to the new law.
To the new law.
On the slides.
Well, we did, but the new law is actually available on the MOJ Ministry of Justice's website. You can actually access the new law there. So if you wish to view the new patent legislation, it's available on the Ministry of Justice's website.
Yeah, so the fees are all there in the schedule to the Act. Fee structure, yes. Mr. Stevenson, yes, sir. The fee structure is all in the law. Yes. So the question from Mr. Thomas Black is meant the changes in the law, just for clarification. Changes in the law as it relates to, let's see here. Table, we could have a table with the old law, just opposed to the new law, to make that clearer. Right, so we did do that in some of the slides. I think in the definition slides, right? But you're saying in terms of the
comparison.
Oh, you mean totally, totally, right? So I mean there is a document that we can share in that regard, or the slide. I mean, really, the slides I think have it just maybe not side by side in a table, but what we tried to do was to show how one slide is old and the new slide what it is, and in some cases it's just a new introduction of a feature in the new law that wasn't in the old law, like the annual fee situation and the mention of the inventor and so on and so like that,
But that's something to consider in the future, that we'll have side by side comparisons to show old versus new. But there is very little. It really is. The comparison is really just a more simplified process, a simplified way, and a more defined thing of what an invention is. So the new law really does speak to the new definitions of what a patent is, and makes a more definite distinction as to what a patent is. And those are the things that we really want to highlight.
Right, I see a question from Sheldon. Will you be able to patent plant varieties in the new Act? So no, the new Patent and Designs Act features or focuses on patents and designs, but we are working on a new plant variety protection bill, right, which will be exclusively now looking at the issue of plant variety protection and creating a new IP regime for plant variety protection. That's also something that is high on our agenda at JIPO, and we're looking forward to that being in place in the near future too. Of course, having to go through the process, but the bill is well advanced in that regard, and we're just looking to know, have it finalized, go through the process to be approved hopefully in short order. Yes, a very important part of the framework too, certainly for plant varieties, and of course we know of the CLA's interest and role in that regard. So we definitely have that as a priority for us. Not priority to the patent law sense, but legislative priority for us this year. I see another question here. How is the filing date determined where there are amendments to the application required?
So that's a very key point. So based on when you submit all and you satisfy all the requirements under the section of Section 10, then that will be considered your filing date. So it's really important that when you file your application, you must file with all the necessary requirements. so that your filing date will be the earliest date that all the requirements of Section 10 are satisfied.
Right. All right. I'm going to just post in the chat the link to the new law where it can be found. The persons can also check it out at their own time. Right. In terms of where you can get more information on the PCT, certainly there are some links that are quite prominent for WIPO. Generally, we are also working on several information leaflets or brochures that we want to do as well for PCT in this coming year. And also, we intend to do some upcoming seminars between now and June in that regard, right? But certainly, if you want to know what PCT at its core, please just Google WIPO, WIPO, space PCT. You see a wealth of information coming up there on the WIPO website as it relates to PCT, how it functions, how it operates, and what to expect once it's in place here in Jamaica. I think I said that thing too. I think I said that link too. Right. Okay, let me see here. So you should see in the chat now the link. So hope are we going to launch a survey? Please. Any further questions or comments? Anyone would like to answer anything else that we can help to assist? If we didn't answer anything properly, please just let us know. We can go back over any aspect. Of course, this is just the second in the series of patent webinars that we're doing here at JIPO. The next in the series is Mr. Wangsan.
The next in the series we'll be looking at more of the international aspects of the PCT and so on. So we'll be looking to facilitate the new law and how the PCT will facilitate, not be facilitated under the new law. So those are the things that we're looking at.
Right. I mean, we did have a PCT webinar as well end of last year that should be also available on our website or on YouTube. So it's on the website. So, sir, is it on the website?
The webinar?
Yes, we have it. WIPO on PCT.
It should be, or it's on our YouTube.
So it's on the YouTube for sure.
Right.
So if you check out JIPO YouTube, you'll see a webinar we did around, I think it was October or November last year with the WIPO PCT division. And I said we'll be having as well in the next webinar in the series, Mr. Longson explain also for a discussion of WIPO PCT at JIPO and the local implementation of it in the new law. Right. So the poll is up. Please, a few minutes of your time to complete the poll. We do appreciate it. Thanks for your participation and your attendance.
Everybody for that participation, and please keep up to date as to what it is that pictures of the new law. And if you have any questions, feel free to contact us at JIPO as to any questions you might have. And we do encourage you to have a patent and you're close to filing, please file.
Mm-hmm. Right. Sometimes we know the culture in Jamaica oftentimes is to hold on to it and keep it close to the chest.
Yes.
Buried under the ground, and
but it's not.
Grow.
It's not so. The only way it's going to grow is if you take advantage of it.
Right. Or it's a plant variety it might grow, but from that the patent itself, the invention itself needs, to be out, it can be open, or proper legal protection, to be packaged and commercialized for your benefit, right? For public benefit. So that's what we always encourage people to do: patent and invention. I'll work on it, right? But don't sit on it and don't bury it. The world needs it. All right. So thanks very much then again for staying with us this Friday morning. I look out for future JIPO sessions. Thanks to our local in-studio team, Mr. Pope and Ms. Firstman.
That's right.
And a special shout out to our birthday queen, Miss English. I wish you all a peaceful and safe Friday and the rest of the weekend. Thank you.
Thank you.